Good afternoon, and welcome to the Appellate Division First Department. We will begin with the call of the calendar. I will ask you what time you want. And what I need you to give me in response is the time you need, okay? Understand that I have over 6 hours of requested argument time. And I'm not sure who's playing tonight, but I'm sure you guys want to get home to watch the game, okay? So understand that the clock is for you, not for the court. So if you are brilliant and we have more questions, we keep going, okay? So do not fret if I cut your time, which I inevitably will. But like I said, if your arguments are so persuasive and so interesting that we need to ask more questions, I don't cut off my cord, okay? People versus Shaquem Pierce. Good start, submitted. NYCTL 2019 A Trust versus Pulski.
Request 5 and 3, please. Responded to Pulski 5. Respondent board 5.
Okay, let's do 4 and 1, 4 and 1, and 5. D. Leda versus Richard L. Submitted. A.M. Sconzo. Okay, what time would you like? All right, and you are here for? Respondents. Okay, we're gonna do 5 and 1 and 5, okay? Lind versus Tishman Construction. Okay. 5 and 2 and 5. Antonio versus VS 125 LLC. Okay. 5 and 1 and 4. PHC Williams 2 times. We're arguing the case together.
Good afternoon, Your Honor. Appellate request 8 and 2.
Okay. Okay. Okay, that's more than we need for this case. So we're going to do 6 and 1 and 6 and 6. Okay? All right. Vage versus Empire State. I'm sorry? Okay, and how much time would you like? Okay, you are the appellant? Okay. All right, guys, this is not brain science. This is executive order from the Cuomo administration. This has been adjudicated a million times. I'm going to ask again. How much time would you like? 3 minutes. Okay, 3 and 1, 3 and 1 and 3. People versus Maurice Hill. Submitted. On Offrey versus 243 Riverside Drive. Okay. 3 and 2. Trying to beat each other. I like that. CSN Realty Corp versus 2252 Third.
Good afternoon, Your Honor. Appellate request 5 and 2.
Okay. All right, let's do 4 and 1 and 3. People versus Thurston Stewart. Okay. 6 and 2 and 6. HSBC Bank versus Proctor is a, what do we got?
Appellate request 8 and 2, Your Honor.
No. Try again.
6 and 2.
I don't see a respondent. You scared them away. So I think 3, and if we have questions, we'll pepper you with them, okay? All right. And 361 Broadway is a submit. Wilmington Savings is a submit. First case on the calendar, New York, NYCTL 2019 A Trust. You may proceed.
May it please the court, Stephen Alexander Biolsi for the appellant in this post-tax lien foreclosure surplus proceeding applications by all of the appellants and respondents. Your Honors, the law is crystal clear that once any lien that exists at the time of the sale is a lien that should be satisfied. The sale was in September 14th, 2022. The only lien your honors have before it that predates that is the 2019 lien. All of the other, from the condominium association, all of the other liens from 2013, 2014, 15, and 17, I believe, they've all expired by way of statute of limitations. The Court of Appeals is clear that once you impress a lien, you have 6 years to enforce it. It is either paid off within 6 years or it's time barred. Rather than execute on its 2013, 14, and 15 liens, they commenced an action in 2018 and they voluntarily discontinued their action. They say upon advice of their counsel, I'm not sure.
Well, there was a reason for that voluntary discontinuance. It wasn't just for naught.
Well, because there was a tax lien, but they didn't.
Precisely. So they can't move forward anyway, right?
They could have pled in that case. They could have pled something, which brings me to their other case. They could have pled an entitlement, and they didn't. Had they pled an entitlement to recover the condo dues, then that result could have resulted in the case that the respondent condo board wants your honors to rely upon, the Trencher case. In the Trencher case, a condo board has the right to affirmatively sue or counterclaim or cross-claim as the need may be.
Did the 2019 lien refer to charges from 2013?
Went all the way back, and all of those liens are time barred. And
What case says that?
I don't know if this is a case of first
Oh,
impression.
no.
I'm
Nice
unaware-
try, no cigar, okay? This has happened a million times before. So you tell me what case says that a subsequent lien that incorporates those debts that had been previously filed in a previously filed lien somehow are no good. Tell me what case says that.
It's my read of the Court of Appeals case in Remsen Gardens.
That's not what the case says, though.
And I think the respondents agree with your honor. However, the case doesn't say that you can continue to renew every year.
No, but that's not how we do this, right? So you want us to read the negative into a holding. I need an affirmative holding that says the proposition you are putting forward.
I'm giving you the law, actually.
I'm giving you the law.
The law.
You're giving me your
Interpretation.
suggestion on what you think it means.
Yes, Judge. And
So tell me what case
I don't have,
affirmatively says that I can do what you say.
none of us cited a case to that. I could not find one, Judge. All I found is the law that says that there is no basis. Once the lien is impressed, you have up to 6 years to enforce it.
Is there any case that says that you cannot file a subsequent lien that incorporates the debts previously placed in a prior lien?
No, Judge, I was not able to find one.
Okay, neither could I. So what's wrong with the 2019
Because it-
filing then, which incorporates the debt of 2013
Because
and
then
going forward?
you, in essence, would you would render the statute meaningless.
Not necessarily, unless the statute prohibits that, and it doesn't.
But when we look at the intent of the clear read of the statute says you have 6 years. So for example, in 2013, they had 6 years, which they did in 2018, Judge. In fact, they did. But they didn't preserve that right. They knew they had to sue on the 2013, 2014, 2015.
Which is why they filed a subsequent lien. But you'll
However-
have time on rebuttal. We're not going to debate. Thank you.
Good afternoon, Your Honors. Judge, you've stated my position essentially. I mean, 339Z and 339AA says that there is a continuing lien until the sums are paid or 6 years. That's why we renewed the liens, and the last one was
Well, it
done.
says until no later than the expiration 6 years from the date of filing. So I think the issue is what date of filing are we talking about here? Are we talking about the ones that were filed in 2013 or 2019 that now incorporates those?
Well, there's no bar on filing successive liens. As a matter of fact, If you look at 339 AA, it says nothing contained herein shall affect or impair the right or release the unit from the lien that exists. This is, the board is statutorily mandated to do this to protect the rest of the condo owners. And there's no, look, there's no argument here that these sums were not paid. So, and there's no statute of limitations. If there were a statute of limitations, it would have been listed in the statute. But the Levine case, which he cites in his brief but does not talk about, says it is not a it's not a statute of repose. It's just basically saying how long the lien exists, but it doesn't mean that the lien expires. So I would ask you to affirm. Thank you, Judge.
Thank you.
Good afternoon, Your Honors. Andrew Laufer for defendant respondent Pulski. The property was governed by the divorce decree that was settled into.
Doesn't the divorce judgment make it clear that the sole owner was Bonaventure?
Yes, based upon the payments that he was supposed to make. Those were conditions precedent, and he didn't satisfy those.
Does the statement, does the writing say that?
Yes,
that-
it does.
Where?
The divorce decree says.
No. It says, I know what the divorce, but nowhere does it say, until such monies are paid, this property remains joint property. It doesn't say that anywhere.
No, I don't believe it does, but what we do have is a deed that has my client's name still on it. And there was no satisfaction of payment that was filed by the defendants
But
demonstrating.
wouldn't she only be entitled to that $10,000, which she can start a separate action for to recover?
She
Why
can
is
start-
she entitled to anything more when she released it in the divorce?
Well, because there was a penalty provision within a divorce decree which gave her those additional costs.
Well, those are just costs. It doesn't give her an entitlement to still have title or ownership in the property.
No, it gives her a penalty that the appellant needed to pay my client on top of what he still owed her, which is
Right.
what the lower court gave us.
And she may very well be entitled to that from your client. The question is whether she has some kind of priority over the surplus money at issue here. That's the issue.
Well, Your Honor, it specifically deals, the surplus money comes from the marital residence.
We know that's not the issue.
Is the
Right?
stipulation, the transcript, is this transcript of the stipulation in evidence? Do we have that as part of the
Yeah,
record?
it should be in the record on appeal. All of it's on the record on appeal. It's not in there? Okay. I'm fairly certain it is. The judgment of divorce is in the ROA, as well as the judgment that was garnered once it was entered by the court.
That judgment, when was it filed in connection with the
I
foreclosure
believe
matter?
it was, I don't recall off the top of my head.
Wasn't it filed after the foreclosure sale?
It was filed after the foreclosure sale, but again, it specifically has to do with damages that were owed to my client from the marital residence, from the appellant's failure to perform.
I know, but you want us to tie those two things together, and we can't. So the issue is, again, whether she has any line in priority with respect to the other creditors.
Well, the condo board creditor would obviously be ahead of us. We don't dispute that, and we have no issue with regard to the condo board's right to collect on those fees. We're not seeking in any shape or form to negate that right.
Okay.
We haven't cross-appealed here. We're just trying to preserve what the lower court awarded us. That is simply what we're trying to do and nothing else.
Got it. Thank you.
Thank you, Your Honor.
Okay, you have time on rebuttal.
I'm going to readdress Your Honor's question about the 2019, and I know I was looking at my reply because I was concerned about the lack of my ability to find a Court of Appeals case squarely on this issue. But Your Honor, if we were to just say just the 2019 lien is the only lien that is binding because they can renew, the 2019 lien does subsume within it the 2013. However, when you look at page 140 of the record on appeal, you notice that the 2019 lien is $62,883. So in reply, I did the math because I can't do it on the fly. The respondent was given $225,775.91. That's not appropriate. If your honors believe that the 2019 lien, which subsumes all the other ones, is valid, then by that very document, at best, they're entitled to $62,883, which means they got $162,891.93 too high.
But we know that that's not accurate, right? Because your client didn't pay anything on the common charges for years. But we will take a look at your arguments.
Thank you, Your Honors.
Thank you.
If I could just add one final thing.
No, your time is out. Thank you so much. Have a
Thank you, Your
great
Honor.
afternoon. A.M. Sconzo.
Good afternoon, Your Honors.
Good afternoon.
My name is Gina Bernardi.
Wait, we don't
Just gonna
have
say,
our,
It looks
yeah.
like he's not here.
Why don't we wait? Because he did call, tell us he was on his way. So as soon as he gets here, I will call your case.
Did I, as soon as he gets here? Okay,
As
so
soon
I
as
should
he
stay
gets here. I'm not gonna wait till the end of the calendar, okay?
Very much, Your Honor.
Please let me know when her adversary arrives. Okay, so next case on the calendar is Lind versus Tishman. You may proceed.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant. Let me tell you the claim I'm not making first, and then tell you the claim I am making.
Okay.
I am absolutely not contesting the propriety of the Barrier Against Manglass or Greasy Act case at all. Okay, there's zero question that if you do not make a motion for inconsistency and you make it timely, it's waived. Okay? And I know that because the last case that came down from this court is Albuquerque, which I lost. So I just want to say that right off the bat. But it's absolutely true as well. All four appellate divisions have held that that doesn't bar a claim for insufficiency or excessiveness or that it's against the credibility of the evidence. This case and the other case that I cited, Isaac, has caused me to completely reconfigure what I think about specific interrogatories. I always used to say they were terrible. I'm changing my mind. I think they're great because they actually adumbrate what the jury did very, very well. So here's my argument. This was an all or nothing defense. Okay? Our position was that our client had a vicular necrosis, no question about it. He also had, unfortunately, MS, and he had steroids. He was asymptomatic, or the word that I always use is quiescent. We got the charge. And the defense's position was nothing. He didn't suffer an injury. The word they used was bruise, I'm quoting, or contusion. You can't get $466,000 in past pain and suffering for a bruise, and you can't get $230,000 for lost earnings for that. So the jury in question one rejected that claim. Now, Mr. Gannon's a terrific lawyer. What he says to you in his brief, and it's a good argument, he says, look, Brian Isaac cited to a lot of cases, and a lot of the cases he cites has inconsistencies inter se between future and past. So we all know, because you said it in Scott against Postis, you said it in Porquet, that if you award future lost earnings or future medical expenses, it's kind of weird to say you don't have any future pain and suffering because the award doesn't make any sense. He's right. Except I just want to tell you there are 5 cases that we cited, 2 from this court, Singh against Catamount, Syracuse against the City of New York, 4th Department cases, Grasso against American Grass, 2nd Department cases, Cecile against Green, and Paris against LaPrade, in which the court said that an award of past pain and suffering has to have consequence with respect to the future, and that's what we have here. Now, I anticipate my adversary is going to say, because again, he's a really good lawyer, he's going to say, wait a second, you've got 2 different scenarios here. Couldn't the jury find that because of the plaintiff's prior symptomatology, the pain and suffering would have ended at a certain time? I've got two responses.
Well, I think it's
to
a little bit more than that, right? It's that maybe the pain and suffering is not attributable to this particular thing going into the future.
It is. That's going to be his argument. But I respond to that. The jury doesn't have to accept undisputed testimony. It doesn't have to accept what an expert says in whole or in part. We all know that, and that's what the jury was charged. But I don't think a jury can make up their own medical evidence. So the way that this would have had to have gone down for them to actually do that is to say, look, they would get expert testimony saying, assuming there was no injury at all, do you have an opinion with a reasonable degree of medical certainty as to when the plaintiff's symptoms would have arisen? That's not here. It's a giant record. Nobody asked that question. I'm assuming the reason they didn't ask the question is because no doctor is going to say, oh, I can determine with an asymptomatic quiescent person that in 3 years this would have happened. Even assuming you say, you know what, Mr. Isaac, that's not right. I've got one ace up my sleeve, which I'm going to ask you to consider, and that's the Past Lost Services Award. And I want to read it to you because it's right out. This is what the jury said. This is the question. Did plaintiff Dorothy Lind, and I want you to focus on these words, sustain loss of services, those words, from plaintiff Earl Lind Jr. due to, quote, injuries he sustained as a result of the accident, which occurred at the World Trade Center March 27, 2015? They answered yes. Even under Mr. Gannon's scenario, that can't work. If she sustained the loss of services as a result of his injuries, under that scenario, she's got to get an award. And we know now that the jury's thinking is stilted. Now, what's the remedy? If you agree with me, I would like you to find that the award is inadequate and give me a stip, but I have to be candid. There are cases that say that in a situation like this, you can find it's a compromise. My view of the case law, lead case is Garcia, it's mine. It's a new trial on everything.
If we were to find that she is entitled to some compensation, what do you suggest?
Well, I think
In light of the case law?
yeah, I mean, the case law,
Because,
the case-
you know, I gotta tell you, speaking only for myself, it seemed a bit insane to me that a spouse's value on an annual basis for picking up the slack for an injured spouse would be between $1,000 and $2,000 a year. I am just appalled by that. I couldn't hire someone for a week for $2,000.
in New York, it's going to be 5 days, but
Exactly.
that's neither here. I mean, the awards, you know, there are multi-million-dollar awards. I think that this has to be a you know, seven-figure award or an seven-figure award with some multiple. But what I really want you.
Cases to support that,
Right.
counsel, we would love to see it.
Because the cases really have a range of between 10,000 to 15,000, right?
Well, he's got a different life expectancy. I mean, there were plenty of there were cases, there were $1 million cases, but I grant that those are ridiculously. I'm sorry, my light's on.
Go ahead.
Okay? Those are ridiculously serious injuries, but there are $100,000, $250,000 cases too, depending on what the person's doing. Remember, he was an electrician. He was working at least 1,040 hours.
We're talking about the loss of consortium.
Yeah. But the testimony was that his hips was so bad. I mean, even if you want to look at that, because of the necrosis, that he couldn't even pick up his socks, and he basically lied in bed all the time, and he was a dynamic kind of a guy. So I don't think you're limited to 10,000 to 15,000. But again, I really think that the jury's verdict here, when you look at the overall verdict, just the reasoning doesn't make any sense. And that should go to the main plaintiff's argument as well, because those numbers were just very, very low, given the way the case was tried.
Thank you.
I'll pick up the rest on my reply. Thank you.
Good afternoon, Your Honor.
Good
See why I
afternoon.
like Mr. Isaac as an adversary. Christian Gannon on behalf of Respondent Tishman Construction.
Counsel, how do you respond to your friend's argument regarding the loss of services?
I would say this, that the judge charged the jury that they can award amount for loss of services, if any, and the verdict sheet, which the plaintiff did not object to, gave the jury the option to say none. And I just think, looking at that, they just did not believe the plaintiff. That's the best argument I have for it.
Well, the first question was answered in the affirmative, right? So if it's, the first question's answered in the affirmative, there, it has to flow that a sufficient amount would be some amount, not zero.
Your Honor, it's a fair argument, and I just think the jury, just based upon all that went on in the trial, just
But what case allows us, honestly, I haven't seen one, where you say, yes, there is a damage, but no, you get nothing.
I don't have a case, Your Honor. I mean, I agree.
That's
It's-
because there are none. Once you say yes, you have to affix a number. Even if that number is $10, you have to affix a number. So, again, speaking only for myself, to me, that's a no-brainer. There must be a number attached to a yes answer.
Okay, Your Honor.
So what's your response to what number should be attached to that yes answer? Because you're not getting back, at least not from me, what the jury gave you.
I understand that, Your Honor. And I think the award should be in the neighborhood of, if there is an award to be set by the court, $5,000.
So you think a spouse's value annually for 8 years, we can divide 5,000 to 8 years of this woman having to carry her family all by herself because her husband was injured? You think $5,000
Your Honor, I was saying
is enough?
I was saying $5,000 per year.
Per year. Okay, now we're talking. Okay. All right, that's better. I'm happier with you now. Okay.
Now, in
Because
terms,
I was,
I wouldn't have made it out here alive if I said.
yeah, you know, and you know, if you have a spouse, somebody gonna be looking at you a little twisted. You know.
She's not watching the argument.
Okay.
So, Your
All
Honor,
right.
in terms of the overall argument of the plaintiff's attorney, the jury is not obligated to follow an all-or-nothing approach.
Okay.
I mean, essentially, the jury can determine none of the injuries were caused by the incident, all of the injuries were caused by the incident, or in this case, I believe only they felt that the labral tear was caused by the incident. And we know that because the very first jury note that came out, and this is at record 3863, the first thing they asked for is MRI reports from the time of the accident up to the time of the right hip replacement. They asked for Dr. Stuchin's testimony. They want to know the dates of the 3 injuries. And most importantly, the fourth question on the first jury note says they want to see medical reports prior to March 27, 2015, which is the date of the incident, when Erlin was treated for leg pain and given Vicodin. He was not asymptomatic. Dr. Stuchin testified that he had bilateral pain, lower extremities, he had avascular necrosis, he was on steroids, and he was on Vicodin. And all those records went into the jury. So it's very clear that the jury,
Most of the jury's questions were regarding causation.
they were all about causation. Every single note except with the economic damages, and obviously the verdict was, we want the medical records to make this determination, because they were clearly looking at 2 different injuries. And I believe I think actually the number is high for a labral tear, but I think that's what was done. And the past lost earnings make sense because Mr. Lynn's average salary the 2 years prior to the incident was $78,000, times 3 is $234,000. They gave him $230,000 in past lost earnings. Dr. Stuchin said he will not need future medical care. At the time of the trial, Dr. Stuchin had not seen him for 5 years. He said the prosthetic device would last a lifetime. And his treatment for the labral tear ended in April of 2016. So that's the physical therapy. After that, all the treatment is related to the avascular necrosis, his debilitating hips, and then he has right hip replacement, then left hip replacement. So I think the jury made a decision. Labral tear is related, everything else is not. And I think that's what justifies the number for the past pain and suffering and for no future pain and suffering.
Thank you. Okay.
I'd love to be able to do that also from jury notes, discern what happened. I don't think you can do that. That's a little generous. If you can do that, I'm going to try to take advantage of that next time I'm here. My point again is not, I'm never saying juries have to accept anything in whole or in part. I'm not. What I'm saying is juries cannot make up medical evidence. And here, because we don't really know what happened, and we do have that back award, we can speculate all we want about what the jury was doing, but we know what the jury said. That's why we have jury interrogatories. And question 1 was the plaintiff injured as a result of the accident that occurred at the World Trade Center on March 27, 2015? Defendant's position was no. The plaintiff's position was yes. We won on that. We did not get the money that I think we deserved. But again, I'm asking you to consider the fact that there is no specific interrogatory here saying, would the plaintiff's condition have existed year 1, year 2, year 3, year 4? For general verdict with no evidence. And again, I'm a big jury supporter. Everybody here knows I'm a plaintiff's guy. I've been doing it for 40 years. But juries cannot make up evidence, and they have to base their decision on evidence, and they are certainly not doctors. Without that testimony, this verdict is inadequate.
Thank you.
Thanks for listening to me.
Okay, we now have a full complement, A.M. Sconzo. You were given 5 minutes and 1 for rebuttal.
Thank you, Your Honors. First, let me profusely apologize for being late today, and thank you for hearing me today.
No problem.
Good afternoon, Your Honors, and may it please the court. My name is Kristen Gianaros for the plaintiff appellants in this case. The motion court committed 2 significant errors in dismissing the complaint against Dr. Sconzo in this case. The first of these errors was the motion court's total failure to account for the plaintiff's experts' opinions regarding Dr. Sconzo's departures.
Counsel, I read the plaintiff's experts' opinions regarding the departures, and they all seem to stem from what happened at the hospital once the plaintiff got there. I don't believe that it's your argument that in circumstances where a doctor has notified a hospital that a patient is coming over, and then the hospital, for whatever reason, does certain actions that may or may not be a deviation, that doctor is responsible for what happens. What time does that end? 1 day, 2 days? How can we make such a ruling?
So I'd like to answer that in 2 parts. First, to answer the beginning part of your question, our expert did opine as to the departures prior
Your
to her
expert's
arrival.
opinion was quite speculative as far as I'm concerned. Talked about perhaps this, maybe that. You needed like a dart to nail it down. So
I would disagree that our expert's opinion was speculative. I think he was clearly stating that prior to her arrival, before she arrived and he contacted the hospital, he had a
what
duty
case
to...
says that a doctor who sends someone over from their office becomes responsible for the acts or failure to act of the hospital receiving the patient? What case says that?
Your Honors, I did search for a case to that.
And there
says
are
that,
none.
But I think that the case is the
There are none for a reason.
I would respond to that by
You
saying
would be
that...
opening up the floodgates of liability beyond what is envisioned in medical malpractice.
And that is the defendant's position here, but the case law...
But it is a really strong position. And other than saying, oh, that's their position, what is your response to that?
My response to that is the case law says that the duty of care, it is a question of law for the court to determine. And that question is dependent on the circumstances of the case.
Right, so
Here
what if we have a doctor who has reached out to the receiving hospital and say, you have an emergency situation, this patient needs to be seen immediately for possible delivery, right? He texts, calls, leaves a message to her treating doctor, who, by the way, is at the hospital.
And he didn't respond.
After performing the 2 exams, the NST and the BP.
Correct, and he understood that this was an emergency obstetrical situation.
So other than getting in the ambulance with the patient and walking in the door of the emergency room and saying she needs to be taken immediately to labor, what was he supposed to do?
He was supposed to adequately communicate to the hospital that she was
How
having
did he
an
not
emergency.
adequate? Like I
I'd
said,
love-
he emailed, text, called the hospital and her physician.
And he actually spoke with someone and communicated,
So
with the
I would-
labor and delivery nurse.
I would love to address the content of his communications because I think that's where the rubber hits the road on this case. Dr. Fitzgerald testified that when she spoke to Dahlia, the employee that Dr. Sconzo imparted this information to, he made no mention whatsoever about this being an emergency. He said the patient was coming in for, quote, an evaluation. And when Nurse Dawson, the nurse who saw the plaintiff, treated her, she also put in her note the patient was in for an evaluation. Nowhere in her note did she write the patient is here
Tell
for an
me
emergency.
what doctor can send someone to an ER and dictate what the hospital does?
Even
No.
even before we get to that, though, he
No.
doesn't have to-
That's exactly the issue, counsel.
It is.
He
but-
cannot dictate what the ER and the doctors at the hospital have to make their own assessment. Because if they were to act just on a referring doctor's say-so, and that information is wrong, they're liable. Because they have to do their own assessment.
But defendants don't dispute that he had, at the very least, a duty to impart correct information and to adequately communicate.
What incorrect information
He
did
did
he
not.
impart?
He did not impart that this was an emergency situation that required an immediate delivery.
If we disagree with you on that, then you lose, right? If we disagree that his communication did indeed impart that there was an emergency situation that this patient needed to be handled immediately, then you lose, right?
I would, Your Honor, but I would say that the court cannot resolve that question conclusively and as a matter of law, given the testimony of Dr. Fitzgerald. She said that while she was in the hospital, no one
Dr.
came.
Fitzgerald gets contradicted by her own people at the hospital.
It's a question
So
of
her
fact, Your Honor.
credibility is a bit,
It might be, and I think that's for the jury to resolve, but from her account, nobody approached her in the hospital. No one came in the ER, in the OR where she was
That
operating.
is the hospital, that's the labor,
But
that's
that
the
all
hospital's
stemmed-
problem.
I
I mean,
agree
I don't
with-
understand how you're trying to impose this authority from Dr. Sconzo onto other people at the hospital.
And I want
Right? If he has discharged his duty by notifying the hospital, well, first of all, by informing the patient that she needs to go to the hospital after doing certain tests. And then he notifies the hospital, this patient is coming your way by phone, as my colleague said, by email, and actually speaking to someone. Why isn't his duty discharged at that moment? Now the hospital has to spring into action. Whatever, deviations they might have taken, that is the hospital. What
But
authority
Dr.
does he have over them?
And once plaintiff gets there, doesn't she get taken immediately to the delivery room counsel?
She doesn't. She gets taken to be put on a fetal heart monitor
and
for
who's,
2
but
hours.
again, that's not the responsibility of the doctor who's sending her.
Your Honors, I want to separate here.
All right, you know what? You're gonna be able to tell me that on rebuttal.
Sure, thank you.
Good afternoon, Your Honors. My name is Gina Bernardi DeFalco. I'm here on behalf of Dr. Sconzo and the
Well,
practice.
let's talk about this communication, right, to the labor and delivery nurse. I think that this is what they're saying, that there wasn't sufficient communication in the emergent situation that was happening.
Correct. I think the plaintiff is hung up on the semantics of the word emergency. The fact is, everyone at the hospital knew what Dr. Sconzo knew. At 2:30, there is a note in the chart. It's page 783 of the chart. It's written by a nurse by the name of Dawson. Whether you believe Dr. Fitzgerald that he spoke to Dahlia, the receptionist, and you believe her hearsay of what Dahlia told her, Sconzo said, in the note, it says, she came from Dr. Sconzo's office. She had a BPP of 4 out of 10. And here in the hospital, since
And that equals an emergency.
it should for everyone, right? Their
Yes.
experts said it equals an emergency, but apparently their position is it only equals an emergency for Dr. Sconzo, and he's supposed to tell everyone else it's an emergency because all the other medical providers don't know.
What else could he have done, counsel? What else could have Dr. Sconzo done here?
Things that are outside of his duty, like Justice Manzanet said. Maybe he should have walked the plaintiff to the hospital. Maybe he should have taken out a knife in the office and delivered the baby there. It's ridiculous. It's way outside of the scope of his duty. The plaintiff's argument is encapsulated in this sentence from page 7 of its brief. The hospital's conduct simply does not advance any understanding of an emergency obstetrical situation following Dr. Sconzo's communications regarding this patient. Because the hospital's conduct was not correct, that's Dr. Sconzo's fault. That's their position. The case law is legion that this is not the doctor's duty. And I won't even say the doctor's duty ended when she arrived at the hospital. It ended when he told her, get yourself to the hospital. And I just want to make one other quick point. There is a lot of reference in the briefs to the facts most favorable to the plaintiff. I find it impossible to believe that in this case, the facts most favorable to this plaintiff is to throw out their own testimony, the father, the mother, the nurse, the notes, Dr. Sconzo's testimony, and just believe everything Dr. Fitzgerald said. I understand it's a credibility issue, but that's not the facts most favorable to the plaintiff in this case. And I think Justice Jerez's order should be affirmed.
Thank you.
Your Honor, you asked what else could he have done? And our expert specifically said, at the very least, he could have called labor and delivery and said, Dr. Fitzgerald's not responding her phone. She's the only doctor from our practice at the hospital, and it's probably likely that she's involved with another delivery, which she in fact was. Can you get Dr. Fitzgerald on the phone and make sure she acknowledges that?
Well, actually, Nurse Dawson controverts that, and your client and your client's husband say that they spoke with Dr. Fitzgerald before
Your
Dr.
Honor, I
Fitzgerald was,
acknowledge-
I'm still talking, was dealing with the other cesarean section. So Dr. Fitzgerald was aware of your client's emergency situation when she went to deal with another C-section.
It's her firm and unequivocal testimony. She did not know about this patient. Nobody came into the OR to tell her about this patient. The first time she found out about her was 2 hours after her arrival at 4 p.m.
But
when a
are you
nurse-
trying to create a question of fact based upon the conflicting testimony of the defendant, Dr. Fitzgerald, as well as the plaintiff? Like, how do we resolve that when that's not the issue that we're presented with here, right? That's not the issue, the purpose
Well-
of this appeal. That's between Fitzgerald and the plaintiff. We're here to talk about Sconzo and what Sconzo's duty was.
And what Sconzo did, or did not do rather, is reflected by the information that was eventually imparted to Dr. Fitzgerald. Nobody told her that this patient was there and was in an
Okay,
crisis
that's
level
controverted,
situation.
like I said. Nurse Dawson says exactly the opposite. She says the opposite.
She said she did not recall any of the events in question.
She said the opposite.
But there's no question that he called and he texted.
True, but he did not, after that, take any further steps to make sure this information was in fact routed to Dr. Fitzgerald when he knew that she was probably involved in another surgery, and she was involved in another surgery.
Why would she know that, counsel, you are just adding stuff that has no foundation in the record? But thank you.
Thank you, Your Honors.
Antonio versus 125 LLC. You may proceed.
Good afternoon, and may it please the court. My name is Michael Joseph. I'm an attorney with Cohen and Dyckman. Our office represents the appellants in this matter. And to that end, appellants respectfully request that this court modify the lower court's May 16, 2023 order to award appellant's summary judgment against plaintiffs or respondents on its labor law 241-6 claim explicitly in its entirety. There's a bit of background on this case. This matter involves a plaza construction laborer, plaintiff respondent, who was allegedly injured while using a chipping gun, which she testified spun out of her hand while she was using it to break up concrete at the site.
Yeah, we're losing your voice.
I apologize. Is this better?
Yeah, stay close to it.
Of course. You know, following dispositive motion practice, everything but plaintiff's labor law 241-6 claim was awarded summary judgment to the defendants.
Well, isn't there evidence from the plaintiff that she was having trouble with the gun almost immediately, and that it was getting stuck? And she would have to jiggle it to get it to keep moving. And she kept telling her supervisor about that. Now, I recognize that her supervisor now says, oh, the gun was perfect. I tried it before, I tried it later, there was nothing wrong with it. But isn't that the quintessential issue of fact? Why should I believe him over her and grant summary judgment to anyone?
Especially when he confirms that she told him that she was having problems with the gun.
Well, to that end, there are two issues on that. First, Section 23-9.2A, the liability, the industrial code section that plaintiff is seeking to impose liability on under Labor Law 241-6 only applies to structural defects with the equipment. And further, it doesn't apply to—
Counsel, if a piece of equipment is supposed to operate in a particular way and operates in a different way such that it causes kickback and causes injury to my arm, that, I would say, is a defect that one can consider under the labor law. So tell me something else. You got to have something more than that argument.
Under 23-9.2A, this only applies to power-heavy operated machinery, and that's—
That argument was not raised below, and so this court will not consider it for the first time on appeal. What else you got?
Well, the court does have the power to consider it under Watson versus the city.
We are not going to consider a argument that was not raised below. So what else do you have?
Okay, so under 23.9.2A, there is a discovery trigger. So in other words, the defect that plaintiff is seeking to oppose liability for has to be reported, or the party against which liability is sought has to be
And she
notified
did.
of that defect.
Immediately.
No,
She
so
reported there was a problem.
what the testimony is that she reported was that she had an issue with the chipping gun getting stuck in the concrete, which is something that occurs in the ordinary course of breaking up concrete, while using a chipping gun, not an issue with the gun itself. The only thing that she told her supervisor, allegedly, because he denies that he was told anything the day of the incident.
He did not deny that she told him there was an initial problem. He did not deny that.
He denied that there was any issue with the rotary function of this chip.
Yes, like I said, he said, oh, I tried it before, it was fine. I tried it later, it was fine, yet it broke her arm.
Right, and
Right?
plaintiff concedes.
So obviously something happened.
Plaintiff concedes that she made no complaints concerning the rotary function of the device, so there was no discovery.
Counsel? The record is replete with her saying she complained about this gun, that it was very old, that it was a very worn equipment. And I realize that there is evidence in the record that this piece of equipment was bought a year before. But in the construction industry, that doesn't mean anything, since if it's used every day, within a year, it could be quite worn. So, again,
And her supervisor also said that he did not know if regular inspections were conducted of this thing. Isn't that an
there's
issue of fact?
There's 2 points onto that. One, he testified that the gun had been used approximately 10 times before because there had been
and
another
then he changed it to
subcontractor.
20. So
There'd been
we have a moving target on that piece of information too.
Well, with the respect to the inspections, the manufacturer of the device and an expert have both testified that there's no specialized procedure required to inspect this gun. And Mr. Padovano testified that the gun was looked at every time every time it's taken out of the gang box.
So his expert testimony, this manufacturer of the equipment who would like this company to buy more of his equipment, says, oh, there's no problem. Until the equipment is falling down and your hands broken apart, it's fine. That's basically what his evidence was.
Your Honor, I see that my time has elapsed, but to answer your question.
Okay, you can respond on rebuttal. You're next.
So, Your Honor, if there...
You'll have time on rebuttal.
I'm sorry. Thank you, Your Honor.
I'm sorry, I didn't make myself clear. That was my fault. You may proceed.
Good afternoon, Your Honors. Jack Lockwood for the plaintiff respondent here. This, of course, is the defendant's motion for summary judgment. As Your Honors have pointed out, the evidence must be viewed in light most favorable to the non-moving party. Here, the plaintiff.
What about your adversary's argument that the complaint that she made was about the bit getting stuck, and his advice was, we'll just change it out, but the injury-causing mechanism wasn't actually the chip getting stuck? What do we do with that?
Your Honor, first of all, there's a divergent testimony about how that conversation actually went. What she said is, and at her deposition, what she was asked is, what's the first thing that you said to him when you went? She said, it keeps getting stuck in the cement. He then immediately says to her, well, this is the only gun that we have, so keep using it. Try your best. When you read his testimony, it's a much different story. He tells her, he goes to help her and show her how to, this happens all the time. You have to use 2 different bits. You use the pointy bit to get the other bit out of the concrete. It's a whole completely different story. I would also point out that she testified that the gun was moving in her hand when it was getting jammed and lodged. So although she didn't necessarily say that it was spinning, she did talk about how that it was moving when it got lodged and jammed.
So what about...
She also testified that, and that was she said that it kept getting stuck. That was at page 70. Then she also said the whole gun was vibrating.
And I was just going to ask, what about all the other people who had used the gun afterwards who didn't have any problem?
So, Your Honor, first, Padovano, her supervisor, who I think if you read his testimony, it's pretty clear he doesn't have a very high opinion of the plaintiff. He says that the day afterwards, he went and used the gun. He didn't use the gun to break up this large concrete mass that had a tarp or a demo bag wrapped in it, which was in the basement. He used it to chip a hole. We don't know how big the hole was. We don't know where it was. Then he says, oh yes, and someone else then used the gun to do the job that she was supposed to do. Then he did not personally witness that. He was not the one who did it. He could not identify the individual who did it, and he did not give a date for when that happened.
In other words, that's hearsay evidence.
Exactly, Your Honor, and should not be considered. However, their expert then used that testimony as the basis for her opinion, which is why her testimony should not be considered. It was conclusory and speculative. None of the experts here has testified that it was proper to use the chipping gun in the way that the plaintiff was using it to chip up a large mass of concrete. And although Padovano and I think Liam Kelly, testified that it's normal for the bit to get stuck, neither of the experts testified about that. Neither did the manufacturers say, oh yeah, it's totally normal for the bit to get stuck. Even if it's normal for the bit to get stuck, this was happening repeatedly. And so there's no evidence that...
Isn't the purpose of this bit to cut and chip away rock?
It is, but it also
So
has a drill function.
if a piece of equipment whose purpose it is to break rock always gets stuck while breaking rock, that's not a very good piece of equipment, is it?
Correct, Your Honor. It's not operating properly, which is why we think that there's an issue of fact here as to both of the industrial code violations. Lastly, I just would like to point out that the issue raised for the first time on appeal, ironically, is relying on Masicki, where the Court of Appeals declined to consider that issue because it was raised for the first time on appeal. It's not properly in front of this court. In fact, it was raised for the first time in a reply brief. If Your Honors have no further questions, we'll rely on our brief.
Thank you.
Thank you, Your Honors.
Counsel, you'll have 1 minute.
So with respect to counsel's commentary on the testimony of Mr. Padovano has testified that he had 30 years of experience using chipping guns to break up concrete, and this was a common issue, the bit getting stuck in the concrete while doing that. So there was sufficient support for the expert's conclusion that that is not a structural defect in the equipment. Additionally, plaintiff's testimony is the one, plaintiff's supplemental affidavit testimony is the one that should be discredited here because it actually does directly contradict what the testimony that she provided at the deposition. Although she testified that the gun was old at her deposition, that was later clarified at her deposition to say that it only kind of looked used. She didn't notice any structural defects in the gun. She didn't notice anything broken or in a state of disrepair with the gun, which she was directly asked. Similarly, with respect to the abnormal shaking, she had never used a chipping gun at this site before, or this type of chipping gun.
But she had used a chipping gun before, and she said so repeatedly.
Yes, she stated that she said so, that she had used chipping guns at a prior project, but that's not in relation to this specific type of chipping gun.
Doesn't matter. She doesn't have to have that experience at this site to be able to be credited with having experience using the equipment. And if she didn't have the experience using the equipment, then it seems to me it would be on her supervisor for giving her a job that she was not qualified to do.
I see that my time has elapsed, but to address your last point, Mr. Padovano did testify that he showed her how to use the equipment prior to handing it to her, after setting it up to her, and that the equipment had been used not only by him, but by several other people after the accident without issue or any report of any defect.
Thank you.
Thank you, Your Honor.
PHC William Street Condo versus 156 William Street owner and retail. You may proceed.
May it please the court. Good afternoon, Your Honors. Joseph Pacelli of Wilmuth Martin Deutsch, representing PHC William Street Condo LLC. The plaintiff appellant in two matters to be heard today in tandem, stemming from the same underlying case wherein the IAS court erred by dismissing PHC's cause of action for breach of the implied covenant of good faith and fair dealing. The underlying case centers around PHC's ability to, or lack
So
thereof.
how do we get to retail if there's no contract between you and retail?
We allege in the complaint that there is a contract between retail and PHC, that all three unit owners are a party to the condo declaration. All three are the only unit holders in the building. All three have rights to each other under that declaration. All three have responsibilities to each other under that declaration. And that was our assertion in the complaint. And also retail executed a deed in which it explicitly accepted and agreed to abide by the provisions of the condo declaration. And the condo declaration in turn requires...
The condo declaration would be maybe an agreement between the sponsor owner and the unit owners, right? Not between the two unit owners against each other.
The condo declaration is only signed by owner. And it does, that was the ruling by the judge in the IAS court, which we disagree with, and it does not cover, for example, an instance where there could be causes of action between the two unit owners, such as if
Would the unit owners be able to, would they be subject to any other kind of, I guess, regulation, like the Condominium Act or something? Would that give rise to causes of action between unit owners?
it would be up to the board to enforce them against unit owners, but as the board is controlled by owner, there's kind of a conflict of interest there. In some circumstances, there could be, where the owner would have to prosecute claims against its own interest. And that's why we believe that at least PHC would be a third-party beneficiary under the IAS court's ruling, under the condo declaration as it exists between retail and owner, if that interpretation is what this court sees fit. And if it is, if there is a contract between only retail and owner, then PHC would be the only available party to be a third-party beneficiary, and that conclusion's inescapable because there are only 3 unit holders. Neither opposition supports the IS court's basis for dismissal, and respondents attempt to re-argue the merits of their motions to dismiss. This court, as did the IAS court, should not give any weight to these arguments. First, contrary to their assertions, PHC does not seek to create any new duties or independent rights. Rather, the ability to access one's units is fundamental to the condo declaration. And contrary to what respondents argue, the purpose of the condo declaration was not to create landlocked units. The implied right of access naturally flows from the explicit right of use, and an inability to access renders that ownership and the use rights illusory. An owner's argument that PHC has no right to use the lobby misses the point. Owner does not allow PHC to enter the building, which is alleged in several instances in the complaint. And without any reasonable permanent way to enter and exit the building, there could be no exclusive use of the school elevators therein, which the condo declaration explicitly provides. The underlying case centers around PHC's lack of ability to access its condominium units that it owns on the 2nd and 3rd floors of the building. And defendants or respondents are the 2 other unit owners of the building, and they control the access points to get into the building. And they refuse to allow PHC to access their units.
How does PHC get into the unit now?
They don't have any permanent way to access the units. They were recently leased to the same party that leases retail space now. That was a couple months ago. It's not in the record because it just occurred. But that even if that lease, even though there is a lease in place now, that's a Band-Aid to.
So let me get this right. Your client pays for rent on the 2nd and 3rd floor?
They own the
They
units.
own it. And the other parties are not allowing you free and easy access to your units.
Correct.
You are beholden to them to come and open the door.
Correct.
And they refuse you access through 2 other entry points to the building.
Correct.
The tenants from whom you purchased were permitted access.
They owned both the retail space and PHC space. So they owned S1, S2, and S3, and they had their own separate William Street entrance, that was comprised the whole school unit that's referred to in the condo declaration.
Okay. All right.
Thank you.
Explain to me how this works, that someone rents the second and third floor of I'm wrong?
Let me, yeah, I'll clarify.
Please, because I'm trying to understand how this is right.
So
Are you the owner or retail?
I am retail, and I'm arguing first only because on the calendar, I am numerically first. If you don't want me to go first, we can switch.
No, I just needed to know.
Okay. So when it comes to retail, how it works is PHC was the bank that lent money to the person who bought S2 and S3. My clients own S1. They are two different condominium units, S2 and S3. So we have 3 condominium units that are up and down, and then owner, which owns the rest of the building. There are stairwells. There are other elevators. They have used this term landlocked. They are not landlocked.
How do they get in?
They can get in through doors.
Which doors?
Council,
So
look.
there's
Council,
yes.
okay? I don't think it's right that someone pays rent for space and then cannot get into their space. So please, this is not funny to me.
But
I don't see anything amusing about this.
But I'm the retail owner, Your Honor. I don't own, so I'm not in, you're placing, I think, misguided blame, and that's why I want to be clear.
All right.
I only own S1. There is a front door to S1 that leads directly into my client's condominium.
Okay.
That is the only door.
But prior to this, retail owned S1 when BSRE owned S2 and S3, but then BSRE leased space from you, S1, and then they were allowed the access. But now, you have now back your possession of S1, BSRE is not there, but S2 and S3 are occupied by PHC William, and now their access is cut off.
But their access is not cut off. Their access through my front door is cut off.
But the access that was there before no longer exists, right? It's different.
Yes, pursuant to their lease agreement, the access that they were provided pursuant to their lease, they don't have anymore because they didn't have a lease. He was correct in that now they have made a deal with my tenant. So these are schools, I want to be clear. It was a blue school, it's still a school. So there are children in these spaces. Accessing through the front door is not as easy as being like, hey, you can march anyone through the front doors of our school. It's a middle school, I believe, too, and I think or it's an elementary middle school.
So it's better through some back door, through an alleyway?
It may or may not be, but that's not for me. I don't control those spaces. The common stairwells are not in control by my client. My client is the retail owner only. There are other stairwells, if you're looking at the—
How do you get to the stairwell before, like, upon entry?
There's a stairwell directly to the left of my
That goes straight
client's
to the
space.
street?
That goes directly to the street, yes.
And isn't that an emergency exit that has an alarm that goes off every time you open the door?
It does not have an alarm, no.
But is it an emergency exit?
I don't know if it's qualified. It doesn't, I don't know what you would qualify as an emergency exit. It is in the plans as a required fire stairwell. That doesn't necessarily, I don't know if that makes it an emergency exit by what you're saying in the sense that you can't go up and down it. The documents, even their complaint, allege that they're able to go up and down it. They're not saying they don't. They just don't have unfettered access, which doesn't make it—
They can't just open the door whenever they want and access the place that they've leased.
They could if they want to. They haven't
there
taken
no-
any action to do anything.
Isn't there no doorknob on the outside?
I think there is now. I think there is now. I don't know if there was then, but again, I don't control that stairwell. So I don't want to keep belaboring that, but I don't control that stairwell. But I think what we're getting away from is, and Your Honor has harped on it multiple times today, show me affirmative authority that grants you what you're asking for, which is that the condo declaration is a contract between unit owners that is enforceable.
Well, what about the Condominium Act? Because we have used the Condominium Act in prior cases to allow these kinds of actions between unit owners.
If they have cited an authority, a specific authority that will allow it in a specific instance, I would have to evaluate it. I don't have that before me.
Well, doesn't real property law section 339 subsection J permit unit owners to commence actions like this?
Yes, but that's not a contract pursuant to the condominium declaration, which is required for a breach of good faith and fair dealing. That's all we're talking about here. The easement, the underlying easement questions, is still being litigated.
All we're here on is the claim for breach of good faith and fair dealing, and that's a contract claim. So while you might be right, if there is a right under the Condominium Act, that's not what we're here for, because it requires a valid contract.
But we're here
between the
for
parties.
repleting, right?
I'm sorry,
And we're here to deal with repleting or amending the complaint a specific way. And so presumably, if the Condominium Act was a way to do that,
We could grant that relief.
Yes.
Respectfully, you can do whatever you want, right?
That's true.
But in fairness, while it's not on the record, this complaint has already been amended twice after this motion to dismiss. Not once have they added that back in. They've had every opportunity to do that, coming to the court to do that. First of all, to your honors to do that when they could have filed a motion to amend on in the underlying case. They haven't done that. And they have amended twice as of right. They didn't do that. Even after being told on the record, you can do whatever you want. If you want to assert a different cause of action, do it. In fact, they did change their causes of action. I know I'm out of time. If you have other questions, I'm happy. I think the only other issue I would like to, and we haven't gotten to, is the third-party beneficiary. That was not
30 seconds.
That literally was not pled anywhere. And Your Honor just had a case where you said it wasn't preserved for argument, and I would argue that it's equally not preserved for argument here. They have to bring it up somewhere. The complaint, the first amended complaint, the second amended complaint, and I think that goes to what we were just discussing. So I settle on that. Thank you.
Thank you.
Thank you, Your Honors.
So why no access?
They do have access, Your Honor, and it's in.
Through a door that you only just recently put a doorknob on? I mean,
And
we're making school children go through this, counsel?
No. This is not a school. This is a hedge fund. These folks are a fund. As my colleague said, these guys are a bank who lent to the school. The school is no longer there. The school disbanded in 2021 and is no longer there.
So the bank should be treated like garbage because
No.
it's a bank? I mean, come on.
No, not at all. And in fact, they haven't been treated like garbage, Your Honor. And he's even said they've now been able to enter into a lease.
well, let me ask you this
for those
question.
spaces. So how has
The declaration, is that now an enforceable contract between you and the owner, sponsor, and the unit owners?
So we are not the declarant, actually. My client purchased the office units, and that's all we purchased. We are not the declarant. Maclo.
Defendant 156, the owner and sponsor?
Yeah, but we purchased the office unit. That's a different entity, and it's owned by the Maclo entity. And we are not Maclo. We are LaSalle Investment Management. We purchased just the office unit. And so we are not the declarant. We are not, Your Honor. But let me get back to the issue of the lease.
So whose responsibility is to provide access to those top floors?
There is a board that now runs the building, and there are a managing agent, just like in every other building, and they can call the managing agent and say, hey, we
Gee, let me into the space that I'm leasing and paying for.
They do own the space. They don't lease it, Your Honor. They own it. But that's
So that's even worse.
No, but that's exactly what their predecessor did. Their predecessor was gonna buy the 3 condominium units, S1, S2, and S3, but they didn't have enough money to purchase S1.
I don't understand what all that talk has to do with access to what they do own.
And again, they have access, and on paragraph 86 of the complaint, they say that they have access to it, and that's
Right,
on
but
R64.
is it sufficient?
But
Right?
that's-
Is it what was there before? I think that's what the issue is. No, if you have access, but it's now more difficult than what was there in place. I think that's why we're here.
You're right, Your Honor, and that goes to the easement claims, right? Because easement by necessity is showing absolute necessity. All we're here for today is breach of the implied duty of good faith and fair dealing and frustration of the purpose of the contract. And that purpose has not been frustrated. Why? Mr. Pacelli just
So then there
got
is a contract.
What?
There is a contract?
Assuming that the condo declaration is a contract, that's it. But Mr. Pacelli has admitted that they were able to lease it at above market rates for 30 years. And they've been able to get the use out of the property, and that's frustration of purpose, and that purpose has not been frustrated here. I agree with you with respect to the easement claims. Those need to be litigated, and they are going to be litigated. But as to the breach of the implied duty of good faith and fair dealing, there has been no frustration of the purpose. They have been able to get maximum use, and Mr. Pacelli just said, we've entered into a long-term lease, and they have gotten the benefits and the fruits of the contract. If your honors don't have any further questions,
Thank you.
thank you.
I'd just like to.
Do you now have unfettered access to your space?
Well, because of the lease, currently they can enter through S1, but if they were to default on the lease, we would be right back in the same situation.
Well, if
which
you
is what
default on
initially
the lease, you're on your own, right?
Right, so then we would be right back where we started. I'd just like to raise that record page 185, list 156 William Street owner LLC as the declarant, despite respondents saying that they weren't the declarant of the condo declaration. And I'd also, on the third-party beneficiary point being raised for the first time on appeal, I'd just like to point the court to Edge Management Consulting, Inc. v. Blank, 2583D 364. And if there are no further questions.
Thank you.
Thank you.
Vage versus Empire State. You may proceed, counsel.
Thank you. May it please the court, the instant appeals from a decision and order which denied the motion of the appellant Jones Lang LaSalle, Inc. for an order dismissing the complaint filed by respondents on the grounds that the claims alleged in the complaint are barred by the applicable 3-year statute of limitations. Based on the statute of limitations, respondents' time to commence this action ended September 11, 2021. Respondents filed the summons and complaint January 4, 2022. Respondent relies upon Governor Cuomo's executive orders as a basis for the late filing of the complaint, and appellant respectfully takes the position that the executive orders should not apply to this litigation. As this court is aware, the executive orders suspended all statute of limitations due to the COVID-19.
Is that what our case law has said, that it suspends it, or does it say that it tolls it? Because I think we've settled this particular area of law many times.
Hence your argument time.
It has been resolved here that it has been told. Respectfully, we
And if, in fact, the executive orders did toll the statute of limitations, then this action is timely, right?
That would be correct.
Okay.
Okay. We do ask that the court consider the fact.
We are not going to reverse ourselves and the legion of cases that we have followed in this regard.
We understand.
So your one and only bet is the Court of Appeals, and I don't think you're going to win a cigar there either. But good try.
And I just want to point out the fact that the plaintiff or the respondent in this case did not make any explanation for the filing when they did, despite the fact that they had 10 months after.
Doesn't have to.
Okay. Thank you very much.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
Richard Mendelson for appellants Diva Properties and SL Green. This court has decided in the past this issue. And what we are asking is the reconsideration. We know the court has already said that it would not reconsider in other cases. We feel this case is a little bit...
Understand that it's not just this bench that has decided this way before. Almost every single colleague of my court has issued at least one decision in this direction. So you are asking the 5 of us to overrule the other 16 of us. That is a very uphill climb for you, my friend.
It certainly is. And we acknowledge it. We acknowledge that in our briefs as well. What we would like the court to consider, though, is with regard to the arguments that we have made. And I know that others have made this argument as well. The executive orders were issued at a time when all heck was breaking loose. The wording of these orders was
Counsel,
could have been better.
All of these arguments have been made before, right? No, this is not a novel thing that we're hearing from you.
No, it's not.
You're not blazing any new paths here. We have decided this issue.
With all due respect to you, of course.
Yes.
And we do understand that. But in this particular case, we're asking that the court not just blanketly apply it because, as counsel said, the cause of action accrued on September 11, 2018.
Do you agree that if the executive orders told the statute of limitations, as we have held numerous times, then in fact this action is timely.
We do, and that's why we're asking that there be a reconsideration or at least a balancing here with respect to plaintiff had a year and a half to file before any order was
Yeah,
issued.
you
Plaintiff
want
had
us to
10
create a Pandora's box. Thank you.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honor. Joshua Block on behalf of the plaintiffs. This court has ruled, the second department has ruled, the third department has ruled, the fourth department has ruled. Recently, the Court of Appeals in footnote 2 of matter of Jamie versus City of New York said the toll is a toll. It's been relied upon by the various district courts, the Northern District, the Southern District, the Eastern District. I think I forgot the Western District there. If you guys don't have any questions, I will rest on my brief.
Thank you.
Thank you.
Anything? Thank you. Have a good day. On Offrey versus 243 Riverside Drive.
Good afternoon, Your Honor.
Good afternoon.
My name is Kevin Murtaugh for the defendant appellants, Your Honor. What brings us here today is whether or not the court should have allowed us to pursue our claim for contractual indemnity. The court ruled that since we didn't include that in our notice of motion, that based on that one case, that court shouldn't have to go rooting through the paperwork to see whether or not they should decide that issue. We believe, Your Honor, that this was an abuse of discretion in the sense that
an abuse of discretion when you don't ask for the relief?
Well, we did. I guess what I'm saying, Your Honor, is that we did ask for it in the body of
In the notice of motion, it said that to dismiss all of plaintiff's claims along with all cross claims. There's no mention of Costin or the.
No mention of what, Your Honor? I'm sorry.
I don't know. Costin.
Oh, Costin.
There's no mention in the notice of indemnification. It says all of plaintiff's claims along with all cross claims.
It's true, Your Honor. I'm not going to tell you that it's not. You know, what I'm suggesting to you, Your Honor, is that it is contained in the body of it, and what's contained in there is it's certainly not prejudicial to ask the third-party defendant to address this. This is a contract that they've been aware of for quite some time, and it was briefed in the court below. And I respectfully submit that contract is one which certainly not only they're aware of, but also it doesn't run afoul of the general obligations law. It certainly
Counsel, what language did you actually use in the proposed amended complaint?
What language did we use?
Yeah, did you use language of the indemnification that you were seeking?
Yes, I think so. Yes, Your Honor. Yeah.
So your proposed amended complaint was correct?
The proposed amended complaint, Your Honor, I think doesn't contain, the proposed amended complaint I don't think does contain that, Your Honor. It doesn't. But the amended complaint, the original third-party complaint certainly does that, you know, with regards to Nova, the Nova third-party complaint. What I'm suggesting, Your Honor, here is that we certainly have a third-party, we certainly have a contract which is, again, doesn't run afoul of the general obligations law, and it should be considered now in the interest of judicial economy. Why is it that this isn't a novel contract? It's a contract that.
I mean, counsel, where would that leave us then if we allowed such lax interpretations of the CPLR? Where does that leave us?
Which section of the CPLR? You mean
2214.
2214. What I'm saying, Your Honor, is that there are other cases that we've cited, second, third, fourth department, that said when we put in the motion papers such other and further relief as the court may seem just and proper, you can certainly consider that. And that's all I'm asking for here, Your Honor. I have to concede that it wasn't asked for in the motion, but I do believe that it should be considered now, and there's no prejudice to the defendants, and if there's nothing further. Thank you, Your Honor.
Thank you. Counsel, you have 2 minutes.
Good afternoon, Your Honors. May it please the court. Michael Zhu, appellate counsel to Roland Henderson, attorneys of record for the third-party defendant. I think the panel has a good understanding of the reasons why the order should be affirmed. I just want to point out one thing. Counsel said that there was one court and from the second, third, and fourth departments. I just want to point to a 1971 case from this court, Rudin versus Rudin, cited in my papers, that held expressly that if you have a notice of motion that is deficient, a court is not required to look into the papers. And I quote, I had a quote from a Seventh Circuit court in my brief that said, "Judges are not pigs who hunt for truffle buried in the dirt." So,
I don't think that this is a good quote, especially when you're talking to five
I'm saying
female
they're not.
justices, okay?
Judge Manzanet, please, I'm saying judges are not. And so
I'm
that-
just saying.
So from that,
I don't want to be compared to a pig ever. Okay.
which is why I said they are not.
Okay.
From the Seventh Circuit. The Seventh Circuit actually did say that judges are not required to look into records
You could have just said that.
in motion.
Okay, why
I
you
actually
need to
should have.
say?
I'm sorry, I
I
apologize.
would have stopped with that, yes.
And it's late, and I see my light is on. Thank you.
Thank you. Thank you so much. CSN Realty Corp. versus 2252 Third Avenue.
May it please the court. Joshua Siegel for appellant. Your Honors, there are two fundamental issues on this appeal. There was a third in the interim between when we filed our brief and counsel for respondent filed their opposition brief. They sought to amend the operative judgment, reducing it by $600,000. So that's not on the table, but I think it is indicative of the problems that Justice Cohen had with this case in entering judgment for $3.6 million, 600 of which had already been paid. The first issue is...
Hence the amendment.
Hence the amendment.
Okay.
Although I'm sure if there was a basis to have kept the $600,000, that argument would have
But
been
of
made.
course.
What's $600,000 between friends?
Right.
The fact of the matter was, these were friends. They were members of the same community.
And of course, that doesn't matter. So
It-
let's get to the terms of the contract and why you believe that your client only has to pay $600,000 as opposed to the additional terms that were added in the second amended agreement.
That's correct, Your Honor. So the first issue is there are a number of issues with the sham closing. The seller wasn't there.
Well, that's what you call it. That's what you call it. A sham closing. The only party who didn't appear was yours.
On call is still not there, but the closing itself was described, the property was wrong, the deed was wrong, but most importantly, they did not have a payoff letter. This was not an insignificant problem.
What do the permitted exceptions that your client agreed to mean in that context?
I'm glad you asked, Judge, because the permitted exceptions do include the mortgage, but what it doesn't include is satisfaction of the mortgage, and there's a specific section of the contract, 10.07, that requires a payoff statement at closing. Why? Because without the payoff statement, the title company could not render insurable title for the property. This was not just a fundamental...
I don't understand. I don't understand. If one of the permitted exceptions is the mortgage, then saying that there was a requirement of satisfaction of the mortgage seems to fly in the face of that statement.
It doesn't, Judge. It just
It
like-
does.
Well,
That if you satisfy a mortgage as opposed to, or subject to it, those are two very different things.
The mortgage is different than the satisfaction.
Having closed yesterday, those are two very different things.
Your Honor, the point that respondent has made is that they could have, had the property closed, paid off the mortgage. The mortgage was an exception, permitted exception. What they didn't do is know how much to pay. They never notified the title company. They never notified their lender. There was no mechanism in place to effectuate this at the closing. The closing was a sham. They didn't have the paperwork.
Didn't they notify the title company and the title company didn't respond?
There is not only is there nothing in the record that shows they notified the title company, but we have an affidavit that was submitted to Justice Cohen that was uncontradicted, an affidavit from Continental, the title company, that said they could not would not, they could not insure title without the payoff statement.
That doesn't mean they didn't get notified and didn't respond. So you're not answering my colleague's question.
There's nothing in the record that shows that they were notified. There's absolutely nothing in the record, and in fact,
You
evidence
mean other than them saying that they did notify them? That is something in the record. You may not like it, but it actually is
Well,
something
remember,
in
Judge,
the
this
record.
was summary judgment granted before the end of the discovery. So what we have is their claim, oh, sure, we did, but there's nothing showing that they did. And in fact, the title company said they were never notified. There's also nothing in the record, again, burden of proof on summary judgment motion. There's nothing in the record from the plaintiff in this case that
What
they
we
notified
have
their
is
own
a
lender.
Counsel, I need you to slow down. You're not in front of a jury, okay?
Sorry, Your Honor.
We have a second amended agreement with terms your client signed.
Correct.
Right. And they're bound by those terms.
Correct.
So that's what I'm looking at. What do those terms require?
The terms of the
And so those terms require.
You're talking about the extension.
Counsel, I'm still talking. Required $2 million to be added. It also required $20,000 a month for an extension fee, and an additional $30,000 a month for escrow deposit.
I also want-
None of that was paid.
Correct.
Am I correct?
You are correct.
So why should that not be a part of the assessment of what is due, since the second amended agreement supersedes the first agreement, which limited the recovery to $600,000?
May I, Judge?
Yes.
So you added a part at the end. It's superseded. It does not. I have it right in front of me, and what it actually says is that all of the terms of this contract are hereby ratified. That's paragraph 6, record 211. Second Amendment, paragraph 6, all other terms are hereby ratified. The original,
So if there are terms in the second agreement that are in conflict with the first agreement, then the second agreement controls, no?
it doesn't say that.
I'm saying in terms of contract law. Wouldn't that be the case?
Your Honor, there is nothing contradictory about this, because if you look at paragraph 4, it provides that the escrow deposit of $2 million.
So your argument is that notwithstanding the additional requirement for dependent to pay $2 million in additional escrow deposit to be applied to the purchase price, and an extension of $20,000 per month beginning on March 1st, 2020, and an additional $30,000 per month escrow deposit to be applied to the purchase price, I should ignore all that?
No. You should not ignore all.
So how does that play out in terms of what your client should pay? And please answer, you have the time.
You should not ignore that for 2 reasons. The first of which is that if you see that this is an additional escrow deposit, it's not additional monies. It was always contemplated that these parties would go to closing and this would be paid. It would be if they paid an extra 2, it would be deducted from the $12 million.
Where does it say that?
It says to be applied to the purchase price, $2 million. $2 million additional escrow deposit to be applied to the purchase price. So if they paid the $2 million and the purchase price was 12,
And the escrow deposit is what you claim
funds towards payment.
the $600,000 he's limited to, right? That was an escrow deposit, correct?
The contract is
Counsel, answer my question. Was the $600,000 from the original contract that was placed in escrow an escrow deposit?
It was, Your Honor.
Okay, so then the $2 million under the second amended agreement that is supposed to be an additional escrow deposit, why is that different?
Because it was never paid. It was never invoiced.
Oh, so somehow you renege on your deal and
never
you
invoiced
should
it.
get a benefit from that?
No. The consideration for the Second Amendment is found in the first paragraph. We released the $600,000. We gave it to them.
That wasn't the consideration was for you to get more time to close.
Correct. And as part of the consideration, we released the remaining $600,000
And
into their
added
possession.
this additional language.
And we added this,
which you were supposed to pay.
Judge, the sole remedy provision still applies.
From the first amended.
And it says
That's for
ratify
us
in the
to
First
decide.
Amendment. It says
All
ratify
right.
in the First
You'll
Amendment.
have time on rebuttal.
Thank you, Judge.
Good afternoon, Your Honors. I'm James Riley, Oved Noved LLP, on behalf of Respondent CSN Realty. It's obvious that Your Honors have read the papers and have educated yourselves very well on the record, so there's just a couple of points that I wanted to address. So first of all, counsel, this whole idea that counsel raises of my client didn't attend the closing, it's simply not true. My client's attorney was at the closing. The closing was actually held at my client's attorney's office. The attorney was there. My client hired a stenographer, and my client was at his own office 5 minutes away, and he testified to this, and it's in his affirmation. He called every 10 minutes.
Counsel, what about your adversary's point regarding this payoff letter? and the mortgage being paid off prior to closing.
Right. So the payoff letter is it's really kind of a red herring and a non-issue for several reasons. One, as your honors noted before, the existing mortgage is a permitted exception under this contract. So the parties bargained for this permitted exception of the existing mortgage, and in fact, the contract states that not only is the existing mortgage a permitted exception, but also and financing statements ancillary thereto. And that's in Schedule B of the contract. So it's not just, council is trying to draw this distinction between, well, the existing mortgage is one thing, but the payoff statement's another. It says it very clearly in the contract that not only was...
the issue with the title company and not being able to ensure, and I just want to direct your attention to the emails on this particular issue.
So is Your Honor asking about the notification to the title company? Because the emails are very clear. That's another. It's something that's just simply not true. Record page 1190 is an email in which my client's attorney emails the opposing client's title company and says, "Hello, hi," and I'm obviously paraphrasing here. We're doing there's been a TOE closing, time of essence closing, noticed. We are doing the closing. We would like to give you all the information that you need, the address, the time, everything you need. Please just confirm that you are the correct title company so we know that we're telling the correct person to show up at the closing. Tellingly, later in that same email chain, the title company, appellant's title company, then forwards that email to appellant and says, like, should I answer? Should I answer? Like, so it's not that they didn't get it.
I guess the question really is, without the payoff letter and this argument being made that title would not have been cleared and you wouldn't have gotten, the title company wouldn't have given any title insurance, how do you respond to that?
So again, it's a total form over substance kind of non-issue because they're saying.
Well, the plan was to have the proceeds from this sale pay off the mortgage and all of that sorted out at closing, correct?
Well, exactly, and at closing, it is undisputed that CSN and its attorney had statements. They may quibble with the form that the statements were in, but there were statements showing the exact amount of the existing mortgage. And I can tell you it was $1,322,453.05. So it's not like they didn't know. It's not like they had no idea, oh my gosh, maybe, and this is a $12 million purchase price for this property.
And the paying off of an existing mortgage is typically done at the closing table, at almost every single closing under the universe.
Absolutely, absolutely, Your Honor. And so this isn't a situation where, well, gee, I don't know, maybe it's 100 million, maybe it's 500 million. They knew literally to the penny, and there's no dispute. It's in the record that we had the statements and we were there and we were ready and we were waiting and they just never showed up.
Okay.
If you honors have no other questions, thank you for your time.
Thank you. Okay, I'm gonna give you his extra 30 seconds he left over.
Thank you, Your Honor. Thank you, Your Honor. I appreciate it. So first, on the mortgage statements, that's when you get a balance from the bank and it tells you how much you owe. That's not a payoff letter. Because a payoff letter provides the exact per diem interest and the exact amount required for the bank to satisfy the mortgage and the title company to insure the mortgage. There was a comment about form over substance. The entire purpose of this closing was to effectuate a potential transfer to a purchaser and then base the non-appearance of the purchaser for a default to get a windfall. And it is a windfall, judges. Let's remember, they now have $600,000 and they still have the property.
That's usually
Nothing
how
has
that
changed.
works, when it's in the contract and the buyer does defaults on the closing.
Exactly. And what's also in the contract is provide a payoff letter under 10.07 of the contract. They didn't do that. All the other problems that they had are just demonstrative of their ill preparation for this closing. The least they could have done in order to declare my client in default was
oftentimes at a closing, if there is a recent payment on a mortgage, that payoff number changes. And all that happens is lawyers get on the phone with the bank and the bank faxes over the new number and it gets written into and checks get cut at the table, counsel. This isn't rocket science, but you gotta be at the table to be able to dance, right?
Except here, Judge, we have an affidavit that's uncontradicted from the title company saying that they could not have and would not have insured title that day.
Okay.
Your client never paid any of the amounts, other than the 600.
I'm sorry?
Your client never paid any of the other amounts.
I do believe we paid the first 80 on the Second Amendment, Your Honors. That was, I think, not part of the requested judgment, although the 600 that was paid was included there. In the 30 seconds I have left, please, I would like to...
You're out of time, but I'll give you 30 seconds.
Thank you, Your Honor. I appreciate your patience. I cannot emphasize strongly enough that there's a contradiction here. If the closing was ineffective, then it was a breach by the seller, and the $600,000 needs to come back to the buyer. If the closing was effective, we still have the issue of the sole remedy provision. As we've discussed, the Second Amendment...
All right, we've already gone over this. We've gone over this.
The Second Amendment ratifies the original
Counsel,
contract.
we've gone over this. That's your argument. We've heard you.
Thank you, Your Honor.
Thank
Appreciate
you.
your time.
People versus Thurston Stewart. You may proceed.
Good afternoon, Your Honors. Ronald Zapata with the Office of Appellate Defender for Mr. Thurston Stewart. So Mr. Stewart's 2013 conviction was unconstitutional and should not have been considered a predicate conviction here, when the plea colloquy shows that he presented a defense to the charge, but the court failed to ensure that he understood the defense and was retracting and waiving it. During the plea to attempted second-degree burglary, Mr. Stewart stated that he went into the subject apartment to tell the occupant to close the door, thereby presenting a defense that he did not enter with the intent to commit the crime.
The court didn't follow up on that, correct?
Yes, Your Honor, the court did not follow up on that. The only thing the court did was focus on whether he took items, and therefore implied that merely taking items was sufficient to constitute the burglary. But the court was required to inform him about the defense, explain it, and tell him that intent.
Instead, the court was like, no. That's not the right answer for a plea. Didn't you go in there to steal something? And then the guy says, yes.
Exactly, Your Honor. So the court, once he gave a defense, it should have explained the intent element, should have explained you presented a defense, that's a defense, you have to waive it or retract it now, and the court didn't do that. In terms of the prosecution and the court below's decision, they try to parse these words that do not explain the defense whatsoever. The court below said that by stating, you're here accused of going to somebody's apartment to steal something, and then him saying, yes, I took items, he's only affirming that, yes, I took items. There's nothing in that statement saying, informing him at all
That
about
was
the
his
element.
intent.
Exactly, especially intent at the time of entry, which is such a nuanced, strange thing that's unique to New York law. Like a normal person, especially someone here who has mental processing issues. He has brain damage from falling on his head. He's not going to understand that from
And to be
a mere
clear, the
application.
court was aware of that condition of your client.
I'm not sure about the 2013 court, but the court that reviewed yes, was aware. That was the neuropsychological report was part of the exhibits that the current court reviewing the predicate reviewed. And therefore, because of that, it was unconstitutional and should not have been considered a predicate conviction. Unless there are any other questions on that, I'll move on to what I hope would be the remedy, which would be the court. I would like the court to resentence him rather than remanding. I know remanding is usually
That's typically what we do where a court has not had an opportunity to
Yes, Your
opine,
Honor.
right?
Yes, Your Honor. I guess I've cited just some cases that show that when the lower court has showed that it was willing to do a minimum sentence before, that this court can take that prerogative and do that. And here, the court chose to do a minimum sentence on the persistent violent, and I would think there, as well as when you see the plea allocution and the sentencing minutes, defense counsel below made a good record showing how the court was involved in the plea negotiations and was very involved and wanted to have a lower sentence. And also, if this court was to do the sentencing, then I believe this would avoid any prejudice that might occur with, obviously the court shouldn't consider this predicate conviction. And so this would avoid any kind of prejudice of the court seeing that its decision was overturned and still be considering something that it shouldn't have been. So I feel like it'd be in the interest of justice for this court to.
But now you're saying that we should anticipate that the judge is going to be unduly harsh and not give the judge an opportunity to, again, chime in.
Well, I would just put this all the puzzle pieces all together, where if the court already was doing a minimum, was already going under what.
Well, you could put that together for the trial court.
Right. We got it.
To put it together for us.
Yes, that's true.
We got it.
Okay, and I'll save everything else for reply. Thank you.
Thank you. Counsel, you have 6 minutes as well.
Good afternoon, Your Honors. Jacob Marcus for the people. The court did explain the intent element when they said that you're charged of going into the dwelling to steal something.
Right. No, he didn't explain it. He dictated what was required. There was no explanation. He said, no, that's not the right way to say this.
Yeah, I think that upon defendant saying, I went there to tell them to close the door, the court said, you're charged with going there to steal something. And
Right, but they said, no, that's not a plea. You're here accused of going into somebody's apartment to steal something. Defendant replied, yes, I took some items.
That's
Think
correct.
that's sufficient?
I think it is. A Lopez further.
How does that tell me I took some items, that was his intent at the time of entry, which is what is required under the case law?
Particularly when the statement that he made, that I went in there to tell the dude to close the door, that shows his intent at the time of going into the apartment.
Well, I think that the going into this like in-depth instruction about intent has to be formed at the time of entry. I'm sure the court would have done that had defendant said something along the lines of like.
But was the court required to do that? Because that's what the case law says.
The court is required to do that when defendant actually implicates that in their negation.
And what does it mean to say that I went there to tell him to close his door?
So I
What
think
does that mean?
that is disavowing criminal intent, right? So then what the court says is, no, you're being charged with entering with criminal intent.
He doesn't say that.
He doesn't say that.
It says going into somebody's apartment to steal something. So had defendant said something along the lines of, well, I went in to close the door, and then once I was in there, I did decide to steal
Why does
something.
he have to say that extra part? I went in there because the intent is formed at the time of the entry, right? We can agree to that.
Yes.
And if he says at the time of the entry, I went to tell dude to close the door, why does that not negate intent?
Well, I think it does negate intent.
So then at that point, when the judge hears that, why does he not have to take that inquiry further, right? And explain, well, you now have raised the defense. Have you discussed this with this particular defense with your attorney? Do you want time to discuss this with your attorney? Anything. There was nothing other than saying, no, you're supposed to say that you stole something.
I don't think they didn't say you're supposed to say that you stole something. They reiterated the element of the crime, which is entering with the intent to steal.
Right, but the problem was he doesn't.
No, that's not a plea.
He doesn't.
He should have said, I can't take your plea. You're telling me you didn't have the intent to go in there. Do you need some time to talk to your attorney? Do you want a second call to go outside and see what you're talking about?
Well, I
None
think
of that. He says, no, that's not what you're supposed to say. You're supposed to say you took it.
The court interrupted the plea colloquy, instructed defendant as to the element that he seemed to negate, and then required defendant to say, yeah, I took some stuff. I
The
think that's
element
sufficient.
is what his intent was at the time of entry. And the judge focused on, you went in there to steal something. He didn't say at the time of entry, you had to have wanted to steal something. Is that what happened? He doesn't even say it like that.
That's correct. And of course, we can imagine a world where this further instruction would have been more thorough, but I think this passes constitutional muster. And I will note that the Court of Appeals has been clear that the question isn't to then laser focus on this exact moment. It is after this further inquiry, and I would hope that we can
But
agree
there
that
was no
some-
further inquiry. That's the problem. So the further inquiry did not occur here. So if the Lopez standard hasn't even been met, it doesn't really matter what he says afterwards, right? We're here at the point of did he make the sufficient Lopez inquiry?
I think that to reiterate the element that defendant just negated and ask them a follow-up
Well,
question
his response was, yeah, I took some items out of there. His response does not go to the intent when he entered. And the judge is required to go back to make sure that the response from the defendant relates to what was just negated.
And we note this in our brief. I read that to mean when the judge says, no, hold on, you're charged with going in to steal something, and he says, yeah, I took some items out of there. I read that to mean yes, and I effectuated my intent. I would like to move on just while I...
No, this is the issue. This is the issue. And I don't know about anybody else, but you have not satisfied me that the court engaged in the necessary Lopez inquiry to get you to the next issue.
And that's why I wanted to move on to the remand issue, Your Honor.
Go ahead.
I would just note that it's proper to send this back down. Again, we do maintain that this was sufficient. We rest on the arguments in our brief there, but it should be remanded for the sentencing court. This court is obviously constrained to just this record. The sentencing court can engage in a more holistic approach. The trial
We're not
attorneys...
prohibited from rendering making a decision on resentencing.
I don't think you're prohibited, as in you're not allowed to do it, but I think the vast consistent practice and one that's been endorsed by the Court of Appeals is to send it back down. I'll also note that obviously defendant has been incarcerated. This would be an opportunity to view his behavior during incarceration. And to defense counsel's point, I would hope that our trial attorneys are capable of sentencing defendants consistent with the law. But if Your Honors have no further questions.
Thank you.
Thank you.
Yes, Your Honor, unless you guys have any questions about the plea, I guess the only thing I'll mention is in terms of if there's a remand, another consideration is about what the sentencing range would be, which would be as a second violent, it would be 5 to 7 years. He's already served close to 6, so any delay would prejudice him if the sentence was going to be less than 6. And so that's another reason why this court might want to decide in the interest of justice to do the sentencing instead.
So you're saying if our decision would negate a persistent violent felony offender status,
Yes.
what is the maximum sentence your client could be sentenced to?
As a second violent, it would be a maximum of 7 and a minimum of 5. And so he's already served close to 6. And so any further delay, if he was going to be sentenced to say 5 or 6.
And as a second felony offender, there would be a corresponding PRS time?
Yes, of 5 years.
5 years, okay. All right, thank you.
Thank you.
Thank you. HSBC Bank versus Proctor, last but not least.
I was just going to say that. Good afternoon, Your Honor.
Good afternoon.
Last but not least. My name is Ron Nimkoff. I'm counsel for defendant appellant Kay Medrano. Given my three-minute time limitation, I've thrown out my prepared argument, and I want to simply say that the lower court stripped my client of her interest in a valuable New York condominium through this residential foreclosure action, even though she was never served with process, and thus, even though the lower court never acquired personal jurisdiction over her. While there is an affidavit of purported personal service in the record at page 48, my client fervently denies ever having been served personally with any of the requisite documents. Tellingly, the affidavit of service misdescribes radically my client. The affidavit of service provides that she was in her 50s when she was 74, provides...
So were they describing her daughter?
I'm sorry, Your Honor?
Were they describing her daughter then?
I don't know. I don't know.
And in which case, that would be an appropriate service, since that's someone
Well,
of suitable age and discretion?
Skipping ahead to the proceeding, as I think Your Honor is referring to, before the lower court justice
Right.
when deciding whether to sign the order to show cause that, in which my client was seeking, among other things, to stay the foreclosure sale, the lower court said, okay, this is an affidavit of service, affidavit of personal service, but what he said was, quote, clearly apparent what happened was that Susan Proctor, my client's daughter, who was also a mortgagor and a defendant in this action, was served on behalf of herself and served on behalf of
Her mother.
My client.
Was there anything in the record that said that on the particular day when the daughter was served as the mother, which is what we can see because the affidavits are pretty similar as to the description, was there anything in the record that said that, well, no one was home that day, that's not my address, or anything of that nature?
No, there's nothing in the record to that effect. But, and I think this is of critical importance, after we pointed out in our subsequently submitted papers to the lower court, after he said that it's clearly apparent what happened, that Ms. Proctor was served on both occasions, once on her own behalf and once as a person of suitable age and discretion, he said that there was then a 308.2 mailing within 10 days to Ms. Proctor, and so it was satisfied that way. But then we pointed out in our papers that was a 3215G mailing, and it couldn't be both. It couldn't be both. So that after it was pointed out to the judge that it couldn't be both, he completely switched gears, did a total 180, and said, never mind my pages and pages of transcript where I says it's clearly apparent what happened here, that Ms. Proctor was served on both occasions, but that the affidavit is sufficient to show that contrary to everything I stated during that proceeding, the affidavit of service sufficiently demonstrated that the service was personally made, hand-delivered to my client, Kay Medrano, and it was not.
Thank you.
Thank you, Your Honors.